barriers, and I think one of the main barrier that we're having with our clients is not being able to have that personal interaction that we've always been used to having. Being able, I think, as from the defense community, you always want to, not only because you do see your clients as people outside of their cases, but it's very important that your clients also feel that they're seen as people. And so some of the barriers just for health and safety and having clients is the having to do teleconferences or talk to them on the phone, not being able to have clients come and see you in the office. And in my jurisdiction, not being able to physically go into the jail to go and see clients. And so one of the difficulties, it's easier for the clients that you had the ability to start a relationship with, and this has transitioned and we're going through this together. It's more difficult for the clients who you're now picking up during this pandemic, and those are your first contacts from a distance. So I think that's
your clients at all right now in the jail.
We're not able to go in and visit clients. I think there's a protocol that if there were, special circumstances, but just for a general, I'd like to go in and have a client meeting, that doesn't meet those, that would not meet that criteria. So our jail, it's not that we can have no communication with our clients. They have set up, quite quickly set up a teleconferencing option. And so you can schedule a meeting with your client, but you can't physically go in and have that interaction.
Kim Stover, I think you told me that there's been a pretty good degree of success and eventually some unity about trying to get as many people out of the jail as possible, both pre-trial and post-trial. How did that come about in Alexandria?
I think it was over a little bit of time as the crisis was developing, because some of the things that were being asked for were very different than what our jurisdiction was used to, even though I think our jurisdiction had turned into the direction of starting to do personal cognizance bonds and not ask for cash bail. Mm-hmm. Even though we started to turn in that direction, clearly this pandemic has asked for a stronger response. And so initially, I think that we weren't as much on the same page as people were adjusting to what this requires beyond necessarily just the criminal justice system, but for the individual safety of the people incarcerated and for everyone who has contact in the community as a whole. And I think as that picture started to really, really set in people's mind, we started to look at the cases. When I say we, I mean the other individuals who maybe were had ability to assist or stop the process, prosecutors, judges, things like that, started to look at it as how much is this really a requirement that these individuals be held? So a lot of offenses that individuals may have previously been held on, they were being released. One of the main barriers, I think, in the beginning was that those decisions were initially, I think, left to individual prosecutors who are handling cases. And because of that, there was kind of a difference. People are different. And so there was a difference of opinion about how those cases should be handled. I think one positive transition in their office is that they put it seems like they put the authority of that decision-making in the hands of a single prosecutor, and that helps make those decisions work better.
Yeah, I think in Fairfax, we see a lot of variation in approach. One day, someone will be arguing bond motions and everybody gets out, in part because of the gravity of the challenge we're facing in the jails. And another day, a different person will be there and you get different results. Obviously, it's true about judges too, different days, different results. Parisa, how has your office tried to deal with, I don't know if there's a modification, if you're changing the way you approach bond motions, how have you tried to deal with getting people out of jails, both pre-trial and post-trial?
Well, we came in on one of the sort of core principles of the office was going to be that we are not seeking cash bail. Either, we're going to be honest and just ask for somebody to be held, or try to get them out with sufficient conditions and supports and services to help make sure they show up for court and to help make sure that they get back on track. And we were already reducing the jail population. But pretty early on, the public defender and I and the sheriff and I got together and realized that what we really needed to do was to thin out the jail population, both for the safety of the people who were incarcerated, but also for the safety of the sheriff's deputies and all of the people that come in and out of the courthouse. And that our well-being was very much tied to each other's well-being in a way that had not been obvious pre-COVID, I would say. So we started, initially we got some lists and we started just going through the lists to make sure we asked the question for each person, does this person really need to be there? And so we were pulling files and proactively calling defense attorneys and suggesting that they file motions for a reconsideration. And the public defender was doing this at exactly the same time. We were lucky that we have a good relationship. And so we were talking about the cases and we were collaborating. And, obviously we can't let everybody out, but trying to get as many folks and to be as surgical as possible, to really ask the question, is this person really going to flee? And is this person really going to reoffend?
You've seen some substantial reductions in your prison population over the past few months.
It's been about 25 to 30%, I think, if the numbers are still accurate as of a few days ago.
Yeah, we've seen a pretty big reduction in Fairfax too. I think we're down below 500 people in the jail now. And as you said, I think a lot of jurisdictions have, the prosecutors have gone through and tried to identify people who are appropriate for release, even if they're serving sentences, even in cases where it was an agreed sentence. What, if any, other tools are you guys using to try to reduce the number of people in the jail?
I don't think we're using any other tools. I think, where the public defender filed a very large brief with about 70 individuals listed, and we again collaborated and started looking at those cases before the brief was filed. But mainly it's, I shouldn't say, from the back end, I should say, that's what we're doing. From the front end, we had the conversations with the police, and the sheriff had the conversation with the police department. So they're actually issuing summonses now more than they are arresting people. And so they've tried to pull it back that way. And in the initial bond hearings, we're still, trying to be as surgical and careful as possible to make sure that as many people as can possibly get out, particularly pretrial. And I worry really a lot about the pretrial folks because they haven't been convicted of a crime yet. And so it's particularly important that we don't put them in a position where they're likely to become sicker when they haven't even been convicted of a crime yet.
Kim Rolla, I know Legal Aid Justice Center has been involved, among other things, in monitoring and trying to track what's happening in terms of jail populations and prison populations during COVID-19. What are you seeing in terms of variations from jurisdiction to jurisdiction? Is it mostly the same kind of reduction from place to place, or is it variable from county to county?
Yeah, so I can start with the jail numbers. They vary widely. I'm not sure if how many folks saw Governor Northam's press release that he put out, I think about a week and a half ago now, citing he had issued together with a number of the Virginia Association of Commonwealth Attorneys, the Defense Commission, the Sheriff's Association, kind of put out these joint recommendations. And this press release from the governor said, our recommendations have achieved a 17% reduction in jail population statewide, which we were intrigued. We were like, the jurisdictions that we've looked at and sent public records requests for, we've seen some differences in those numbers, and actually we're able to get state compensation board data for each of the local and regional jails throughout the state that are bi-weekly numbers starting March 1st and going through April 14th. And the variation stretches all the way from a 50% reduction in jail population to a 2% reduction. The numbers, I will give the caveat to say that home electronic monitoring is actually still included in the population numbers, since they consider those people to be in the custody of the facility. So that skews it slightly, but not quite. I think it's total in the jail population, they had about 300 and some folks that were on home electronic monitoring when they ran these numbers. So it's not a huge impact overall, though for some jurisdictions it may skew a bit. But I think that, you know, to use the statewide average doesn't really paint a picture that reflects the reality in each jurisdiction across the state. And I really think the local actors, as both like Kim and Parisa were just discussing, are really they're the ones that are creating that reality on the ground. And we're seeing very different actions from different folks. And the prison population is a different story. I'm happy to talk about that now or later.
Well, I do want to touch on that idea about local actors, because I feel like one of the things that's so frustrating about Virginia's criminal justice system is the variance that you see from jurisdiction to jurisdiction, the way that people charged with similar offenses find themselves in much different situations, depending on, for example, who the Commonwealth attorney is, whether there's a public defender's office, who the judges are, and how the judges approach some of these issues. And it seems like inevitably you're going to see a lot more response to the COVID-19 crisis in some jurisdictions than others. The announcement that there's a 17% statewide reduction obviously tends to sort of obscure some of the differences that we see in some of the injustice that it causes, the inequality, really.
Yeah, and I think another thing it obscures, right, is the accountability of those local actors. When there's not really even an ability at most local level, you actually have to send a public records request. You'd have to send a Freedom of Information Act request to ask the superintendent or the sheriff what the jail population is. Very few facilities are offering that information proactively. Same thing with COVID-19 positive tests in the local and regional jails. That's not it's not easy to determine. So when you talk about the variation among local actors, we also have a situation where their constituents are not able to necessarily tell what's happening in the court system right now, and tell their elected officials whether they agree with that or not.
I'm curious as to you mentioned the prison populations. What are we seeing in terms of infections in our DOC facilities? How's DOC responding to these issues, and what, if any, information are we getting out of DOC?
Yeah, I can give a high level information on the data we have, and then the release mechanisms that VDOC, or really VDOC and the parole board and the governor's office have been employing in limited ways. So the Virginia Department of Corrections, to give credit where it's due, they have been much more proactive in releasing data on testing. So there's actually a daily update that goes up around 5 p.m. every day that totals the number of people in VDOC custody who have tested positive, the number of people that are currently hospitalized, and sadly the number of people who have died while in VDOC custody, as well as staff members that have tested positive, and that's broken down by each facility. I can provide that link in the chat pod in a minute, but the most recent numbers that I pulled right before this call is there have been 456 people who have tested positive in VDOC custody. 12 people are currently in the hospital. 2 people have died, a woman at the Virginia Correctional Center for Women in Goochland and a man at Deerfield Correctional Center. And 64 staff members have tested positive. So folks who are not familiar with VDOC numbers, there are about 30,000 people in VDOC custody and about 13,000 staff members. So that, I don't have the exact percentages for today, but we've been comparing them as a proportion to the proportion of VDOC populations tested positive versus the general population, and the positive test rate, it's much higher, as you would expect. And so those are what the numbers are. They're updated daily, and they're quite concerning. And as far as the release mechanisms, folks may know that last week, last Wednesday, when the General Assembly's veto session occurred, the governor had proposed a budget amendment that expanded VDOC release authority to allow them to release people up to a year early, and it excluded certain folks who have been convicted of a class 1 felony or a violent sexual offense. But other than that, folks who are within a year of their release date could be considered for release during the state of emergency. We just learned on Monday and confirmed again today at the governor's press briefing that only 62 people have been released under that provision. It was passed. NBDC had said that they were preparing, they identified people, but the numbers of release are still quite small. The parole board has improved its release or its approval rate, but it's still the really small numbers. Only about less than 3,000 people are eligible for parole. Only 95 people were approved in March. So we're really looking at, for VDOC, what are still quite limited release mechanisms that are being used, and the governor has really resisted calls to employ any kind of broader clemency authority.
And so the parole measures,
quite high positive test numbers in VDOC custody, and really low release numbers thus far.
so the parole, at least in terms of the power that the Kim, can you hear? Okay, I was in terms of the scope of the executive authority to release people from prisons. We're just not seeing it measure up to. Do we know why? Do we know where the resistance is?
So I'm having a little bit of trouble hearing you, Andy. So I might ask you if you can move on to another speaker.
That's fine. I'll do that. Thanks.
Better place for internet connection.
So let's talk a little bit about the courts. Obviously, there's a number of challenges in trying to operate a court system during a pandemic. I think most jurisdictions are seeing that we're proceeding on some emergency motions and little else. Parisa, what kind of issues are you facing trying to get hearings on, trying to address even minor cases, much less jury trials or motions to suppress in serious cases?
Sorry. Obviously, we can't have any jury trials
No.
because we can't ask jurors to come in and sit in close proximity, and we can't bring witnesses and do all of that stuff. And it's hard to have. We have not been able to figure out how to have preliminary hearings, which would be sort of the first step in a serious case to prove that there's probable cause, and you would want to put witnesses on for that. And it's hard to ask civilians to come in and mill around and be close to each other.
Sure.
And the sort of the technology is just not where we want it to be in terms of being able to have. I mean, we're experiencing it now, right? We're having difficulty, doing things without stalling, without sort of talking over each other. So it makes it really hard to do a direct examination or cross-examination. And then we have the additional problem of where is everybody? So we haven't figured out a way to do any kind of hearing where the judge and the lawyers don't have to be present. So we've been able to do in custody video arraignments and bond motions with individuals who are at the jail, and that's about it.
Kim, I know that you and I are in the same position in terms of what our jurisdictions are doing. They're trying to figure out how to do things like felony pleas or hearings in which there's nothing contested, no evidence to be taken. Are you able to proceed with felony pleas yet, Parisa?
No, we haven't done felony pleas. We've done a few misdemeanor pleas in GDP where a defendant happened to show up, and we're trying to do a little bit more, but you know, for mostly technological reasons, we haven't been able to do that. I mean, one of the issues that one of the courts rightly raised is what happens when a defendant has a question and they need to speak to counsel. Well, if they're not in the same room, they can't really do that. And we can't really be asking defense attorneys to go into the jail.
Right. And obviously, for those that don't know, the entire purpose of a plea hearing is to inform them of their rights, make sure that they're a knowing and intelligent participant in, giving up their rights to a trial. And if they had questions about their rights, and they often do, our clients often either don't understand or just need clarification before they proceed. Obviously, that wouldn't work. Other times, and I think Kim and I have both had this experience. Other times your client wants to say things out loud that they probably shouldn't be saying in a plea, and it's the attorney's job sometimes to lean over and say, I'll answer that question for you later. And if you don't have the ability to talk to your client in that moment, it can be very troubling. Kim, you guys are having the same problems in Alexandria in terms of trying to get felony cases moving?
Yes, I think that most recently that they have tried to put together a policy to make it happen, because we do have, because of COVID, we got some technological advances in our own courts. They're doing video things in JDR court, they're doing video things in GDC court, and also doing video things in circuit court. So it's the technology doesn't seem to be so much the problem, it's how to make it work for what we need to do. And so I think one of the main issues, I know every jurisdiction is not like this, but as I said earlier, we're not going into our jails. And so to have that type of paperwork, which is written a lot in a lot of legal wording, to try to go over that and explain that with your client when you're not able to be there physically with them. There could be some regular comprehension problems because a lot of it is in legalese. There could be comprehension problems because of other things that are going on with your client, and you not being able to be right next to your client, slowly going over with them in depth what it is that they need to understand is difficult. Trying to pass that paperwork into the jail and get their signature without you physically being there, and how all that would work and when that would be arranged. I'm not sure whether we've worked out the kinks. I've not had to do one of those yet. I think the policy is more recently in place. I might have to do one in the future, and I guess we will find out what some of those problems might be.
And from our perspective, at least as public defenders, it's one thing to have your client out on bond. Their case gets delayed. It causes them some additional anxiety. They want the case to be resolved. They want to know what's going to happen. It's another thing in cases where our clients are held, and it creates such a challenge because there really are a lot of reasons to think it's even if you try, even in a perfect world, a jury trial or a plea presents various challenges. But when you're in a situation like this, it's so difficult to go forward with those hearings. And yet, if you don't go forward with the hearing, someone who's held, they get held longer, they get held without due process. And in some cases, it seems to them, at least, that they're going to be held indefinitely. I won't talk too much about individual clients, but I certainly have clients who are sitting in jail right now who would like to have their cases resolved, think that either they'll be found not guilty or that they'll end up getting less time than they're going to end up serving as a result of having to sit pretrial in jail. Is there any way, I'll direct this to everybody, is there any way to resolve wanting to keep people safe and deeming that at least some portion of the population needs to be held pretrial, but also protecting their rights as these cases get continued for who knows how long?
think you might have to call on us, Andy.
Go ahead, Parisa. This is what I get for waiting for volunteers.
Talk about that.
It's like I'm teaching a law school class. You ask a question, you just get silence.
I mean, what you're asking is
Parisa, I'm assuming that you're not volunteering to release everyone from your jail just now.
I mean, no. I mean, what you're asking though is, I mean, it's really like the core question that existed before COVID-19, exists during COVID-19, and will continue to exist after COVID-19, which is, you know, how do we balance safety and due process? And you know, I don't think there are easy answers, especially not for people who are on the side of reform. I think if you're not on the side of legal justice reform, what you say is lock everybody up, and you know, don't do the crime if you can't do the time, and you know, if you're in, you're in, and we don't care. We're not going to have a, you know, thoughtful analysis about it. But I think for people who are trying to reform and trying to look at things from a different perspective, I think what the challenge that we're facing is, where do you draw the line? It's not an easy line to say only nonviolent people can be released, because not everybody who's nonviolent, who has nonviolent charges, you know, is in a position where they won't flee or won't potentially reoffend. And then the vast number of things that Virginia categorizes as violent crimes are also problematic. So it's very hard to draw the line, and I don't think anybody has a good answer of where that line should be drawn.
One of the things that's tricky about it is a client is charged with a violent crime and treated pre-trial under Virginia law as though they've committed that crime. And when certainly, at least I've had many clients charged with robbery, for example, just to pick one charge, that are not convicted of robbery. I would say that the conviction rate on a robbery charge is extraordinarily low in my jurisdiction. A lot of them turn out to be either assaults or larcenies or nothing, or no one shows up, or the person never didn't do anything and they're not guilty. So there's like a lot of people who are charged with violent offenses, or what Virginia deems violent offenses, but who didn't commit a violent crime. And if those people are getting held for 6 or 12 months before they can have a hearing, you know, that would seem to be an unconscionable outcome.
Yeah, I think I would agree with what Parisa was saying. I think that in regards to the tough questions having existed before, because I think what I'm seeing happening is similar to what's happened before, which is clients making difficult decisions about how to move their cases forward. So for instance, right now, one of the difficult questions is, do you want to waive your appearance? Because you can do this from the jail, which is to a detriment to a lot of our clients, is their participation and their ability to be clearly a part of their own case. Is it physically in their health benefit and interest? Yes, but their cost to that, and would that choice in doing that potentially move your case on forward, so you could say have your preliminary hearing and move it on forward? Yes. And so I think they're the difficult decisions that our clients are unfortunately in the position of making when it comes to trying to get outcomes that they like, which is getting out of custody.
And it diminishes their right to counsel, it diminishes their right to confrontation, diminishes the number of due process rights. And it's a real challenge, because we want these things to move forward. It may prove impossible to move them forward in a way that is legally sufficient, and yet they're in jail. And as a defense attorney who's looking out for my clients, it's an extraordinary, frustrating position to be in.
And I imagine it's probably frustrating for individuals who are in custody, potentially in situations that aren't seeming to be so sanitary. It might be very frustrating to somebody in custody to believe that it's too dangerous for them to go into court, but they can remain in such a condition.
Right. So I want to step away a little bit from COVID-19. I want to talk a little more broadly. Obviously, we're still going to come back at times to talk about COVID-19, but I want to talk a little more broadly about criminal justice reform in Virginia, where it's headed, what effect this current set of challenges is going to have for reform in the longer term. Parisa, I know your office has been doing a number of really extraordinary things in terms of trying to change the way a prosecutor's office operates, in the sense of trying to create criminal justice reforms. What challenges are you anticipating coming out of COVID-19 and over the next several months? Once this thing starts to pass, how is that going to affect the movement for criminal justice reform in Virginia?
Well,
If I can ask you an extraordinarily broad question.
There's going to be a crushing caseload waiting for us on the other end of this. And that's, for us, I mean the entire court system, judges, defense attorneys, and prosecutors. I think that, I mean, I'm not generally a silver linings kind of a person, but I actually think that what COVID-19 has done two things that I think are actually hopefully going to be positive in the long run for criminal justice reform. And the first is it's really sort of laid bare the holes that we have in our system. You know, that we don't have mental health services, we don't have healthcare, we don't have good housing. You know, we do have homeless populations, and you know, we do have people who will continue to commit small crimes because of underlying mental illness, but at the same time refuse to get treatment, and that we have to solve these societal problems. And COVID-19 has really sort of exposed the gap between the people who have and the people who don't have. And, you know, I'm hoping that we will find our way to a better social safety net as a result of it, which I think is tied very much to criminal justice reform, because we can release people, but if we don't have a Department of Human Services to release them to help get them mental health treatment, if we don't have, you know, support for homeless populations to release them to, if we don't have diversion programs to release them to, when it's not really helping them in the long run.
Well, and there are going to be a lot of challenges, but also a lot of benefits to coming out of this. For example, we're going to see jail populations down. We're going to see more people on bond. And at the same time, we're going to see people who aren't able to pay their rent, and people who haven't been receiving the kinds of services they have. If crime rates start to go up as a result of that, how are we going to respond as criminal justice reform advocates if people are able to point and say, well, look, the crime's getting worse?
Well, my response would be, well, it's because we don't have the services in place that we need to. And, you know, we don't have a sufficient mental health care system, an adequate mental health care system in this country. And our jails for decades have been operating as our mental health system, and it's not right. And if you can't expect it to get fixed by people who are on the back end after bad things have happened. It has to get fixed on the front end, and we have to have services for people on the front end, and for services for people to re-enter into, so that we can stop recidivism if we really want long-lasting reform.
Fundamentally, it seems to me that the idea that if we put enough people in jail, all these other problems will be solved is not far-sighted. I do wonder, when we face these challenges, how we will be able to respond. I think the answer probably has to be that when you let people out, when people aren't in jail, you take a risk in every single case. And I think we have to stress how important and how much is gained by releasing people, even as some of those people who are released go on to commit new crimes or fail to appear for court or whatever might end up happening in some percentage of the cases.
I mean, this is a problem really with the way that we talk about public safety, and it's really a problem with the way that public safety issues are reported, because we don't see headlines that say "Dad picked son up from school," which happens 99 out of 100 times when you release somebody. That person is able to go and not reoffend and not get into trouble and not do something worse than they were originally accused of doing. But that's not the headline that makes news. Man takes care of mother is not news. Woman goes back to job is not news.
Right.
But somebody creating it is a spectacular headline. That somebody who was released on personal recognizance or supervision reoffended in a big way.
And it's extraordinarily hard to quantify the benefits, where you can say 47 people last year who were out on bond, or whatever the statistic might be. How do we, and I want to get Kim Stover and Kim Rolla both, how do we better message, how do we better show people the benefits of having fewer people in jail? Is it self-explanatory? Are there ways that we can, as advocates, point out to the system, show the media, show those who would call for more incarceration, the benefits of decarceration?
Well, first off, thank you for your patience. I'm sorry. I don't know what my laptop just did, but
Kim, we missed you.
Yeah, I had stole my girlfriend's computer and that wouldn't work either. So, but here I am.
Welcome
so
back.
I think that there's an acute connection right now, and I'm not sure if people have already talked about it. I know Parisa touched on it briefly, but I think the public health space to talk about COVID-19, I mean, the epidemiological research about the public health impact more broadly of having these hotspots of COVID-19 infection, that, I mean, I feel like it is this acute space to have a conversation about the broader impacts, not just on the human beings that are in these facilities, but that comes out into our communities. Like, that's, people are going, the correctional officers, the deputies are going in and out of those facilities every day, and that's there's direct data that has shown community spikes of COVID-19 when there are these outbreaks in the facilities. So I think that having conversations about the idea that these people we're inextricably intertwined, right? Our communities, these people are not separate from our communities, they are our community, right? I actually was talking with a Commonwealth attorney recently about release decisions that she was making, and she said that my primary response is to and named the population of the jurisdiction that she works for, as if the people in that institution are not also residents of the jurisdiction, right? So I think that I struggle a bit with how to frame the public health piece, because I certainly don't ever want to message in a way that says you should care about these human beings because you because for your own health, right? You may get sick or your family may get sick. Right. I think it's important for us to hold the humanity always of the people in VDOC custody, of the people in our local jails. But I do also think it's important to use this as a way to recontextualize them as full community members, right? That their well-being is also our well-being.
And Kim, for those who may not know, you do a lot of your local work in Central Virginia, the Richmond.
Legal Aid Justice Center. We have an office in Charlottesville and work very closely in the Albemarle, Charlottesville region. And then also I'm based in our Richmond office, so work very closely with Richmond, Chesterfield, Henrico area.
Kim, what do you tell judges when they're saying your client poses a risk? How do you respond to questions? I mean, and you see it at sentencing, not just at bond motions, with regard to trying to convince them that it's better to have people not in jail. I mean, it's balancing public safety against freedom and people's lives and the value of individual people. What do you tell them? How do you message that in a way that tries to dissuade people who think this is really just about how much of a risk are we taking to public safety? Kim Stover.
I think that it has a lot to do with getting your client's story and being able to talk to the judge about your client as a human being, your client's experiences. And that's one thing about being out of custody that is very different from clients who are in custody, because their opportunities to have certain experiences are limited. And so one of the benefits of having clients outside of custody, when you're at a point of talking to a client or talking to a judge about a client who may be going into custody, you get to talk to the judge about your client's day-to-day interactions. You can talk about, their hopes, their dreams, the jobs that they tried to go to. You can talk to them about their experiences with their children. You can talk to them about the neighborhood that they actually live in and things like that. So I think what's important when we're talking about people out of custody right now and dealing with the community that is currently being released is getting to know individuals on a personal level, so that when the court starts to hear more about who they are, they understand that they're not just a term that I hate that we use in court and then our deputies' bodies, that they're not just bodies, they're human beings. And so I think getting details, because I agree with what you said about like the robberies, like when you actually try to get the details of what some of these clients are accused of doing versus the way that it's framed in a big scary charge, if you can get some details about it, if you can investigate it, and then you can put a little bit more meat on the bones to explain and make the situation something that is more understandable and less disconnected, there's less of a disconnect between a judge and the situation. I think that helps to bridge the gap into getting individuals back out in the community. It's not just the situation in its past as well. I think the work from a defense attorney also has to do with what it is that you can find to address what the court's concerns are. So there might be, and I think Parisa is right, one of the main things is the concerns, a lot of addressing them, we're missing things to supply. We're missing mental health, we're missing substance abuse, we're missing reentry job treatment or job training, things like that. But to try to find things in the community, we're concerned about this issue. So this is what we've lined up. Somebody has an interview to go into the shelter. We have connected somebody with the community service board. Those type of things that help the judge have some more options about keeping somebody out of being in custody.
So Parisa, I want to ask you a little bit about some of the reforms that your office is undertaking. I know it's still early in your administration, but what kind of things are you doing as an office to change the way that Commonwealth attorneys approach their job?
Well, to bounce off of Kim Stover's point just now, we are trying to charge and to make sure that the charging, what is charged is accurate, and that we are not stacking charges, that we are not overcharging. And, of course, we don't have complete control of it at the beginning. But, there have been occasions where, we noticed something and we went down and right at arraignment said this charge needs to be changed. And so we're very vigilantly trying to start at the right place, at a place of accuracy, and not use charging for leverage or anything like that. We are not asking for a cash bail in any cases. I know that you want me to talk about preemptory strikes.
I do eventually, yes. Yeah, sure.
So we are not using preemptory strikes. If we need to, strike somebody for cause, we will strike them for cause. But our plan is to, the guidance that I've given is that we don't use preemptory strikes. And part of that is not just, it's because I don't see the trial process as a game. And I don't think it should be a game. We're talking about people.
Just to loop everyone in real quick, for those who don't know the intricacies, before a jury trial starts, we do jury selection, and people can be struck from jury selection if they're not qualified jurors for cause. And then the judge makes a determination that they can't sit, because of some bias or information they have or their point of view. But if they're not struck for cause, each side gets a number of peremptory challenges where they can just strike people off for any reason that is basically not based on gender or ethnicity. And those are struck more or less strategically for the purpose of trying to get yourself the most favorable jury. And Parisa is describing that her office, while they do strikes for cause for people who are not qualified jurors for whatever reason or have biases, they are not exercising their side's peremptory strikes, which are basically just their discretionary strikes. Sorry, Parisa, go ahead.
No, I mean, I've been struck. I've been preemptorily struck
Sure.
before, yeah.
How do you
And
feel about that, Parisa?
I honestly, as a citizen, I felt like I was being prevented from discharging a civic duty, and I felt really like kind of resentful about it. And I've talked to a number of people who also were struck peremptorily, and I think it really does prevent us from getting a fair cross section of the community. And I think it really tells people that they're not enough in a very negative way. And so I think that it's every single person who sits in that jury box is a constituent, and I have an obligation to every single one of those people, and I'm not going to treat my constituents that way.
One of the things that I find in my jury trials, and I don't know if Kim Stover has had this experience, that oftentimes when it comes to peremptories, the prosecutor will just strike the 4 youngest people on the jury. Like it's very hard to know who to strike for peremptory challenges, but it does seem like, I don't think it's a tactic. I think that's just their judgment about who's going to be the best juror for them. I feel like ultimately it's very hard to exercise peremptory challenges with people you know very little about without falling back on some sort of negative impression that you might have on someone based on just looking at them or talking to them for 5 minutes, which
So
can be
Virginia has a very elaborate system where the clerk can put names in a box and twirl it around, and there's actually a statute that that covers the procedure of doing this to randomly strike people. But I think the simpler way is just every other time to strike the last 4 or the first 4, so that it's not with it, so that it's really if we end up with extra people, to just go sort of in order and do it in a way that is it might be biased in terms of which part of the alphabet your name is, but that's the worst. If that's the worst thing anybody can say, that's good.
So one of the things that you mentioned about it not being a game, it does feel a lot of the time, I have to tell my clients this often, a jury trial is not a search for truth. It does not reveal reality. It's just both sides putting on information to try to paint the best picture. And it really does sometimes play like a game. Like we're both trying to manipulate the story as best we can for the purpose of making our argument the best. And it does seem like there are aspects of, for example, peremptory strikes that turn it into a game instead of a search for truth. And it can be very frustrating. It can be make you feel like we're not quite doing this right.
I mean, I think that if we can't do anything about the adversarial system in which each side has to advocate, and of course each side is going to have a different narrative and a different different themes and different evidence that they want emphasized or de-emphasized. But and I think that's legitimate. But I do think that sort of taking somebody's ability to discharge their civic duty away from them in order to gain an advantage is not the right thing to do.
So part of that we've been stressing a lot of Justice for Virginia is the extent to which prosecutors, by charging decisions, by the choice to put on a jury trial, can force, and by the kind of plea offers they make, can force defendants and the accused into awkward, intimidating positions in which, if they choose to proceed to a trial, they face a penalty. And NACDL, the National Association of Criminal Defense Attorneys, has referred to that as the trial penalty, where if someone opts to have a jury trial, opts to have a trial instead of a plea, they face harsher sentences, additional time, mandatory sentences in some cases. And as a result, we have seen over the past 5 decades, the number of jury trials that happen in criminal cases has plummeted to where, well over 90% of all criminal cases result in guilty pleas, or resolved as guilty pleas. And I think the frustration that a lot of criminal reform advocates have is that ultimately, and all of us who have had jury trials have seen it, sometimes you put on a jury trial and the case falls apart. And sometimes it happens as a prosecutor, and sometimes it happens as a defense attorney, where you see what sounded like someone had done something really terrible when actually subjected to sort of some of the pressures of cross-examination and trial, it goes nowhere. What, if anything, do you think a prosecutor's office can do to avoid discouraging people from having jury trials and letting the evidence speak for itself?
I mean, that's another one of those tough questions that, if you're not a reformer, it's very easy to answer. You just charge the maximum and use that as leverage to coerce a guilty plea. But if you are trying to charge with restraint, but also there is a benefit sometimes to pleading guilty. I mean, oftentimes there's a benefit to both sides. But if you're charging with restraint, you still have to make the offer good enough for somebody to want to take it if they do want to plea. So, it's something that I'm struggling with as well. And I'm just going to be honest that I'm struggling with it because I never want to use the charging decision or the threat of a more serious charge for anything that is a whiff of, trying to use it to strong arm somebody into a plea. And so the best I can do is to just charge to as close to accurately as I possibly can.
Kim Stover, what kind of effect can the presence of a 20-year mandatory minimum sentence, or the fact that a jury, if they convict, has to give at least 5 years where a judge can give probation, what kind of effect does that have on someone who is hypothetically telling you that they're not guilty and that they want a trial, but they're afraid of it?
Chilling effect. Has an absolute chilling effect, because seeing clients make decisions like that is something that I've done in my career. I'm sure that you've seen plenty of those cases in your career where you have, it's not even just, client is saying they didn't do it. Like, client has a legitimate good defense, but the fear and the terror of taking that risk, I can't even imagine being in those shoes. The fear of taking that risk to do that, to have your day in trial where it can be decided, versus rolling the dice, trying to have your peers decide it and ending up with a potentially significantly worse outcome. It should not be that way. It shouldn't be that way at all. And so it's painful. I've seen people make the decision that not to take that risk. And that is a painful thing to watch. Absolutely understandable. It's understandable why somebody would do that, but it's a struggle too as being a counsel, because even when you can see those good defenses, not crossing that line between, pushing a client in a direction versus just providing them with the counsel and the information they need to make decisions. It's difficult.
And as a defense attorney, I don't know how many times I've told my client, this is a good offer, you should seriously consider it. And then they take it, and afterwards I'm like, because they had to make a very difficult choice, and they made the choice they thought was best for them. But I don't want to be the attorney who walks away and that client 5 years from now is like, oh, that attorney screwed me. I should have had my trial. I didn't get to have my day in court. And there's all different kinds of penalties, right? It's not just someone faces a 20-year mandatory sentence or a 5-year jury minimum. There's also the guidelines call for 6 months, but he has a 3-year offense on his record that the jury's going to see at sentencing, or he's charged with a felony that they might be able to prove and they might not, but they're offering him a misdemeanor. or he's held in jail and his trial date's 6 months away, but if he pleads today, he walks. There's all different kinds of pressures and penalties that keep people from enjoying the trial right. I've heard people say, I've heard advocates for, banning pleas. Let's just put every case up and have a trial on every case. I can't imagine how that would exhaust the system. But when you think about it as a thought experiment, it really makes you think, if we had trials in all these cases, how many of them would be proven? And it's very frustrating as an advocate.
And the serious cases, I'm going to jump in and talk a little bit about my prior life as an innocence attorney. Right. That happens more often than not in serious cases, more often than you would think, in serious cases where somebody pleads to something that they know that they didn't do, and 20 years later DNA proves that they didn't do it. I mean, a full 10% of the DNA cases that we know without any doubt were exonerations and that the person wasn't involved, we know that they pled guilty to something that they knew that they didn't do. So people are going to do that. And I think it's important that we recognize that people do that in the big important cases when they're actually innocent, but they're also going to do that in the small cases. And I love Alexandra Napatoff's book, where she talks about, the non-sexy innocence cases of people who are pleading to things just because they're stuck in jail and they need to see the light of day. And those are reasons why we shouldn't, hold people in jail unless we have to, and all that sort of thing.
I remember a client who was held on a pretty serious charge that he was eventually acquitted of the serious charge. He was convicted of a minor charge. And he had some training on dealing with very stressful situations. He had some military background. He had been in for 9 months as we were approaching trial. And he told me at one point, he said, I just want this to be over. I just want to know how it's going to end. And he was ready to plead to something that a jury decided he didn't do, but he just wanted it to be over. And that moment has stuck with me for a decade, because it's so powerful that just having that uncertainty alone creates so much stress, even on someone who is trained to deal with psychological stress. It's really remarkable. Kim Rolla, I want to loop you in here at the risk of cold calling you. What kind of effect can poverty have on someone's ability to enjoy their trial rights and to be treated and to be able to pursue their rights in court when they're charged with a criminal offense?
Yeah, well, you all have touched on some of the pieces. My program at LAJC has done a lot of work around pretrial justice, and I think that Parisa already mentioned the secured bond issue, the use of cash bail. I think that that's probably the first thing that comes into folks' minds, the idea that there could be a dollar amount set on your ability to walk out of jail until your day in court. There are increasingly Commonwealth attorneys like Parisa and jurisdictions and judges that are deciding to not make use of secured bond and either make, as she described, the decision that this person is appropriate to be released on personal recognizance, or we're just going to ask the court to hold them. But I appreciate your question, because I think in the pretrial context, there's a lot of nuance there. Even what you were just describing, like someone's pressures to take a plea, right? I was a housing attorney for about 5 years before I stepped into this work. So I think about my clients who were experiencing housing instability, and the idea of missing a rental payment could, cause them to have a tailspin of crisis, right? If you lose your housing, that may cause you to lose your employment if you haven't already. That can put issues with custody of your children and having a place for you to stay and be stable. And all of those pressures are weighing on someone when they make the decision of how to navigate the landscape that you all were just describing. And that's even leaving aside when you come out on the back end, right? If someone did take a plea and they now have something that will show up on a criminal record, right? And we know that that's a barrier to future employment. It can be, given new fair housing guidance, hopefully it will be less of a barrier, but we know people still face barriers to finding housing when they have a conviction. And then you asked about poverty, like the direct financial impact of fines and fees that are tacked on even more so if someone chooses to, take advantage of their right to a trial. We have a lot of clients that come in and have been weighed down for years, sometimes for over a decade, by fines and fees that they just cannot pay off. So that is why my organization is a civil legal aid organization, that we think of ourselves as an anti-poverty organization, but feel it's essential for us to be in these conversations because our work runs through every strand of what you were just describing.
I would be remiss if I did not take this opportunity to point out the extraordinary work that Legal Aid Justice Center did in ending the practice of suspending people's driver's licenses. Was that whose work was that within your organization, Kim, so that we can give them a proper shout out?
So I feel like that you have to give Amy Woolard, our policy person, a shout out, and then also Pat Levy-Lavelle, who litigated Stinney v. Holcomb, which was the federal class action that challenged the constitutionality of that practice.
And then that was officially changed as a matter of law in this past session. So everybody knows, for a very long time, if you got convicted of an offense and you got a fine, or you had to pay court costs, which you do anytime you're convicted of any offense, and you were unable to pay or you did not pay timely, they would suspend your driver's license, and they would not always tell you. Sometimes they would send out mailers that would go to your old address or your last house or somewhere you lived previously. Your license would be suspended. And then because you couldn't pay court costs, you weren't allowed to drive to work. And if you couldn't drive to work, you couldn't make any money. And we would see, Kim Stover, I don't know how many clients you've seen who were charged with driving on a suspended license because they were trying to go to work and then got put in jail for a couple of days and lost their job, and then got more court costs, and then got deemed a habitual offender, and then got year mandatory sentences for driving on suspended licenses. It was really extraordinary cycle, and Legal Aid Justice Center played a huge role in ending that practice.
Well, thank you for the shout out to my colleagues. I would also just say, I know that everyone in this panel knows this, but just for folks that are listening, that court debt is still an issue, right? That's one collection mechanism that was particularly brutal for folks. But I just want to name that even right now, we are desperately trying to help our clients think about how their tax refunds won't be intercepted for fines and fees. That is a really that's the reality that we're talking about here. People that are really struggling to make ends meet financially, and the fines and fees are a significant barrier to people's financial well-being.
Are they going after those COVID checks too?
I'm sorry?
Are they going after those COVID checks too?
That's a good question. I've not
Sure they are. They're going after them whatever way they can, right?
Yeah, I haven't seen that directly, but we do know that it is refund season, and the thing we're particularly concerned about now is that some Commonwealth attorneys do contract with the Department of Taxation to collect some of these fees. So,
Kim Stover, did you want to comment on that?
No, I was way back when you were talking about the driving. I think it just seemed quite obvious how this was to the detriment of everyone involved, but it seemed as if the court system really thought that you could just get blood from a stone, and really people were just electively choosing not to pay. So that's all I was going to say.
One other thing that I think is important to understand about poverty and incarceration, it's one thing, there's a lot of studies that talk about the effect that 3 or 5 days of incarceration can have on someone. And both the law requires, and sometimes our magistrates and sometimes our judges at arraignment keep people for a day or two, and they think it's not a big deal. And the effect that poverty can have can exacerbate the effect that incarceration can have. If I got locked up for 2 or 3 days, I probably wouldn't lose my job right away. As an organization, we're pretty forgiving about people being charged with crimes. But I suspect that the economic impacts would be minimal. To take a couple of days off from work, and the rent would still be paid, but for so many people who live on the edge and are struggling anyway, for them to not show up to work for 3 or 4 days, lose their job, not be able to pay their rent, it's really devastating. And, you know, a lot of these people have a lack of resources in terms of taking care of their children or taking care of their loved ones. And the effect that even 1 or 2 or 3 days of incarceration can have is overwhelming. And to those of us on the job, we know exactly what that looks like. But I don't think that people who pass some of these laws think seriously enough, and some people who enforce some of the laws don't think seriously enough about what a day or two of incarceration can mean to someone, and how important it is to avoid that, even if we're not concerned about pandemic infections or jail churn as a result of COVID-19. That is a really detrimental effect on a lot of people in our society. Parisa, why don't you say something about that? Okay, Kim, were you going to do it? I forgot to call on someone. I just talked and then paused.
No, I was just going to add on to, I think that the idea of people being held in custody is starting to get more attention. I think a thing that doesn't get enough attention for indigent clients is now that we're trying to move away from incarcerating people and putting them on pretrial conditions, that it's a similar effect. And I think recently in my jurisdiction, we started kind of using empirical data to educate and to inform our pretrial agency about the level of supervision individuals should have and what was appropriate, because that was not what was happening. So the idea that your client needs to show up for these appointments for people who are working on a weekly basis during work hours is causing individuals to lose jobs.
To give people a quick bit of background, a lot of judges who say, okay, I'm not going to give anybody a cash bond, I'm not going to make you pay anything, but I'm going to put you on pretrial supervision, which is basically being on probation before you're convicted of a crime. A lot of judges are putting people on pretrial, even though there's really no conditions to follow, just as a way of keeping an eye on them. And as a result, people have additional burdens that may include things like going to visit a probation office or drug testing, even though there were no drugs involved in their case. And those kinds of things are overused and sort of used as a default setting a lot of times, where judges previously would have required a cash bond, and it can be just as difficult.
Right. So bringing more attention to that and making sure that people who are deciding indigent clients' cases, how that really has effects on their lives. Another thing that had come out in our jurisdiction, which has changed now, is that we were noticing that when you appealed your case during that first hearing, to decide whether you wanted to have a jury, or to say, appealed your misdemeanor case, to say whether you wanted to have a jury or didn't want to have a jury, or you were setting your felony case for jury or not a jury. Indigent clients used to be required to appear in those hearings. And if you had a retained counsel, you weren't. Retained counsel was representing you. It would just seem to be like this extra addition to kind of watch and provide that extra reminder for individuals who are indigent. There seemed to be some belief that they wouldn't be able to keep up with their court dates or come to court without having that additional face time. That's no longer the practice in my jurisdiction, but having those type of consequences affects people who can't afford to just take a day off, like the people who are making those decisions about their lives can do.
Parisa, one of the bills that Justice Forward Virginia had in the legislature in the last session was one to allow for appearance of counsel, or to require appearance of counsel at first court appearance, and allow for argument for release with counsel at first appearance. And a lot of the time, especially in jurisdictions that don't meet every day, someone will be arraigned, will be appointed counsel, and it can be days or even a week before they have a chance to get a first bond motion on. We were able to change some things around in our system so that someone's arraigned one day in Fairfax and the public defender usually argues a bond motion the following day. But even for us, we can't act until that day passes, and that's usually 36 to 48 hours that someone's sat in jail, not even accounting for a weekend. What can the system do to get people out of jail pretrial faster? And I'm thinking a lot about cases where we all know they're going to get bond, but they don't get bond at first appearance. They don't get bond from the magistrate. What can we do about that?
I mean, I agree that what we should be doing is probably doing the bond hearing and the arraignment at exactly the same time, and appointing counsel as soon as possible. And there are a lot of impediments to doing that right now that are structural in Virginia. So that's kind of a long-term project. But I think what individual jurisdictions can do, and we are in Arlington honestly struggling with it, is to do the bond hearings right away and at arraignment. And I know our courts would love to do it. I know we would love to do it. Sometimes we just don't get the information that we need to do that in time. And so I'm trying to, one of my goals is to work with the stakeholders to try to get the information that we need to do that as early as possible so that that person doesn't end up spending an extra day. And I've worked in jurisdictions where that happened all at the same time. And, there were, rushed conversations and, interns calling, family members to, and jobs to establish community ties. And, this is all happening in the hallways and in back rooms. And, it's somewhat chaotic, but the people didn't end up spending that extra day or two in jail waiting for the resolution of their case, or at least the resolution of their bond.
I want to try to turn to a couple of the questions that we got from the people who are listening. I think there's a number of us might have some things to say about this one, but I want to open it up, and I think maybe Kim Rolla in particular might have some insight. The question is, although there's currently a spotlight on health problems in jails and prisons, isn't jail and prison always the wrong place to be when you're sick? Shouldn't we be using compassionate release, geriatric parole more often, even in normal times?
Yes. So one of the
may have been a bit of a softball, but
so one of the cases that we have that's ongoing is a case styled as Scott v. Clark. It's a constitutional challenge to the adequacy of medical care at the Fluvanna Correctional Center for Women. That is the women's prison where VDOC sends the women with the most severe medical needs. There's a lot of elderly prisoners there and women who are very sick. So at this moment, we have a lot of women who are undergoing chemotherapy for cancer. They're immunocompromised. And, prior to this pandemic, the medical care was horrendous. The VDOC entered into a settlement agreement that we've had to file a motion for an order to show cause to attempt to have VDOC held in contempt. There's a technical reason why they did not find contempt, but found multiple violations of the settlement agreement. A number of our clients have died while I've worked on this case. It's really some of the hardest legal work I've ever done. And to be talking to our clients every week about attempting to be well during COVID-19, particularly people who have serious medical needs, outside of the pandemic context, is just, it's really gut-wrenching. And I think that one of the, as you mentioned, expand medical clemency. Right now, the criteria, I don't know if folks know this, but that the governor's office has established, if you go to the Secretary of the Commonwealth to see how to apply for pardons, if you're applying for medical clemency, it requires 2 physicians to attest to the fact that you are likely to die within 3 months. That is the scope of medical clemency available. Geriatric parole is it's defined as you are, I think it's you're 60 years or older and have served at least 10 years of your sentence, or 65 or older and have served at least 5 years of your sentence. So there are many elderly people in our prison system who are not eligible for geriatric parole. And even those that are eligible, the approval rates are very, very low. So another conversation we're really trying to have with people in the context of COVID-19 is the aging population in our prison system and the immense medical needs that are that those folks have. So yes, I agree. I think that the last thing I'll say is talking with a legislator who received a letter from the Secretary of Public Safety, Brian Moran, describing how Virginia has very low recidivism rates and that they're very concerned with maintaining those, and they want to make sure if they're going to release people during COVID-19 that they are providing these robust reentry services to keep the low recidivism rate. We're part of the reason the recidivism rate is so low is because people are, the draconian sentences, people are so old by the time they get out of our prison system, that, you know, statistically speaking, the likelihood of recidivism is already quite low. So I think that a lot of people who do not think about prisons regularly just don't realize what exactly our prison population looks like in Virginia.
I want to open up another question relating to crime rates. I think the first question is, to what extent have crime rates decreased during this pandemic, and are arrests down across the board? Are there types of offenses where arrests have remained the same or increased? I will start just real quickly to say that I assign our felony cases in my office, and this is obviously anecdotal, but I have seen a substantial reduction in the crimes, in the offenses that have been assigned to our office, full stop, which either means less people are committing crimes, or perhaps only rich people are committing crimes. But I think it's probably more likely that it's an overall drop. And I've also seen what appears to be a decrease in violent crime. A lot of the offenses that I'm seeing charged appear to be either nuisance charges, or there was a lengthy, widespread sting of online actions. But by and large, we're not seeing the rate and the scope of violent crime that we have previously. I don't know if anecdotally or via data, any of you are seeing information along those lines.
Well, I think that, I mean, I would expect crime to be down right now. I think our jurisdiction is doing something a little different in regards to the way that we're bringing cases in. So when it comes to the actual numbers, it might be a little while to see it, because if you have contact, because we're releasing so many people, if you have contact, we're not even setting your advisement out. I mean, we're not even having your advisement until several months from now. So those cases aren't even coming to our office and won't come to our office until that point. But my understanding is that the police are having less criminal contact with individuals and being more selective, which of course lowers the contact that anybody has to have with one another. And so I think that's accurate.
I'm still waiting before I decide that crime has gone down or up. You know, my concern was that domestic violence would be up, and I know that we've gotten more domestic calls, but fewer domestic violence cases. I mean, I guess I expect to see some weird stuff and unusual patterns because of the mental strain that people are under, and particularly the mental strain that people are under who would normally have gone to DHS, but because even DHS, the Department of Human Services, is reduced in terms of their ability to serve, that we might be seeing, you know, at some point an uptick in some kinds of things that the strain of the times will affect. One of the things that Arlington is doing is, which I think is great, and they just announced it, I think it was yesterday, is doing active outreach to the homeless population, so that we don't end up with a sick homeless population and B, you know, a homeless population that keeps getting picked up for things. And so they're doing active outreach and active education, and really going to find people where they are, which I think is, you know, one of the themes that we should be doing overall in the criminal legal system is meeting people where they're at, but really going out to, you know, actively, you know, seek out the people and, you know, offer the services that they can, and offer the education and offer PPE and that sort of thing.
So I just want to give everybody a quick heads up. We have crossed the 8 o'clock barrier as to which we were scheduled to end. anybody who's one of our speakers, if you got to go, it's okay. I'm going to keep asking questions a little bit because we have, I think, still a little more to talk about. If you're all comfortable, if you're not, it's okay. It's totally fine. I'm just the type of person to just keep talking until someone stops me. We did have one question about, I apologize, I don't know which of the Kims said it according to the question, but there was a discussion about community safety meaning something different now than it used to mean. And I'm going to morph it into the question that I want to ask, which is that for a very long time, judges and community actors have said, we have to do what is necessary to keep the community safe when it meant locking up our clients. And I'm curious as to whether you're seeing the same concern for community safety now that it might mean getting our clients the hell out of jail. I'm specifically concerned about every now and then I hear a prosecutor say something like, the jail is the safest place to be right now. Before we had 4 confirmed cases for people who were being held detainees and 6 deputies in our jail, prosecutors were telling us there's no way that the coronavirus could ever get into our jail. And now they're telling us there's no way that it can spread within the jail. I guess I'm wondering, are you seeing the same advocacy and concern for public health from judges releasing people from jail that they were for holding people in jail? How about you, Kim Stover? Parisa might be like, I'm not really interested in talking about our judges right now. I will. I'll talk about judges right now.
In my jurisdiction, I actually think that, yes, I do think that those are considerations. I think as I was talking about in the beginning, I talked about how that has been a developing position, because I remember in the beginning, even trying to get clients out to shelters, clients that were homeless, like this talk of how is their client better protected if they go to a homeless shelter than they are being at a jail, and having that discussion with the judge about what the day-to-day difference is in regards to contact with other individuals. And so I don't think that discussion even comes up anymore. I think in my jurisdiction, for the vast majority of the cases that we're now, that the magistrates, the jails, the judges, the prosecutors, and the defense, for the majority of the cases, seem to be aligned with not getting individuals into jails and not having them come in and get individuals out from the jails. I think another thing, I was reading over some of the policies that they've been having to change for the jails, the protocols, and I can see just from their standpoint as well how difficult the situation is becoming in the jail, and trying to get it to be something that is cleaner. And so the amount of steps that they have to take for every new individual that they bring into the jail, in our jail, they have to do so many things when it comes to, what type of clothing or protocol or moving or cleaning for every single person who comes in. And those things begin with when you have a first contact with a new person coming in, whether they pass the entrance exam on their questions. And not passing the entrance exam can simply be that you refuse to answer the questions. You're treated as if you're under investigation. And so, especially when we're dealing with a lot of the mental health clients that are coming in, then we have all this special protocol and shutdown in the jail, and it's really causing some difficulty. So I think there's a lot of agreement about trying to get individuals and not have them physically be in custody and get them out into the community.
So I think it's time for me to start wrapping things up. I really want to thank you all for your time. I want to note a couple things real quickly. There's a day of action coming up on May 1st, 2020. Kim, Rolla, I want you to take 30 seconds to tell us anything we need to know about the day of action that LAJC has coming up.
This is perfect because this is actually when my screen froze and you asked me about clemency authority. So bring it on back. So there is a statewide coalition of groups of directly impacted folks whose family members are incarcerated, of local bail funds, of legal organizations, 50 plus organizations known as the Virginia COVID-19 Justice Coalition that has been pushing for decarceration as a response to COVID-19. And there's going to be a day of action this Friday, specifically targeting Governor Northam, with the hashtag No Harm Northam, the physician, Dr. Northam, and asking him to use his clemency authority to reduce the prison population in Virginia. So I will send that action alert maybe to you, Andy, and if we can post it on the comment box or something for the live stream. But we're asking people to call or email or tweet at Governor Northam and ask him to use his clemency authority to reduce the prison population, because that's what's necessary to protect the people both inside those facilities and out.
Thank you so much, Kim. I really appreciate your time and your contributions, and Legal Aid Justice Center, the contributions that they're making as an organization. I'm really glad that we have people doing legal aid work alongside of what the public defenders and the prosecutors are doing. Needless to say, thank you to Kim Stover. Obviously, I have a lot of great things to say about fellow public defenders, and Kim is one of the very best. She is an advocate, and I've worked with her in a number of trainings, and she is a passionate advocate for her clients and for the humanity of her clients. And I want to thank Kim for her time tonight too. And Parisa, who is doing some really remarkable things from a position that usually we have to view as an enemy. And Parisa, along with some of the other colleagues, some of the other people, we talked to Buda at the last session that we did, the last online town hall. Steve Descano, Amy Ashworth, Brian Porter, Jim Hingley. It's great to have people all over the state starting to take reform positions and think differently about what their job can be. Parisa, I really want to thank you for your time tonight and for hopefully giving us some insight into not every prosecutor has to be a bad guy.
Can I just say one thing?
Please.
I am delighted that there are reform prosecutors on the rise, but we couldn't do anything if it wasn't for public defenders, if it wasn't for the defense bar, and if it wasn't for the advocacy and academic community. So, I owe everything to the studies and the meta studies and the advocacy and the hard work and everything that you guys are doing. So thank you.
And if anyone's still viewing now, or if they're viewing it later, I want to invite anyone who's viewing this, if you want to check out what Justice Forward Virginia is doing. We are one of the only groups where all we do is criminal justice advocacy in Virginia. We have legislative work, we have work like these where we have town halls and organizational meetings. If you're interested in what Justice Forward is doing, feel free to get in contact with me, with Brad Haywood, with Brian Kennedy, with any of our leadership team, or just go to the website, go to our Facebook page, which you're probably already here if you're viewing this, and obviously feel free to donate and to help the cause. Advocacy takes many, many forms, and we appreciate what everyone contributes. Thank you to all of our speakers tonight, and stay safe out there, everybody.